My name is Jeff Morgan. I'm from Dallas, Texas, and today I just want to congratulate Josh and Jessica Jaros, and extend my best wishes to them and also to their two children. Congratulations on being able to get 50-50 shared parenting. Congratulations on being able to throw off the shackles of child support that were imposed upon you. Congratulations on actually standing firm and going to court and making sure that everybody got to see what was going on in our family courts. The judge that you had, I thought he was a good judge, but it was really amazing that you had two parents, Josh and Jessica, agree on 50-50 equal shared parenting with no child support. And there was one person who disagreed, one person who wanted to sabotage the whole agreement, one person who was the interloper, the person who was trying to say, no, this can't happen right now, apart from my agreement. And that was Roland Brown from the Office of the Attorney General. I was shocked, and I think everybody was shocked, because usually if you have two people in agreement, that should be enough. But the Office of the Attorney General, in particular Roland Brown, came in and he was not in agreement with this whole situation. Now, he raised some objections, supposedly, that were supposed to be considered, but the question still remains, why is the Attorney General even involved in this situation whatsoever? Why is the Office of the Attorney General even involved in this situation to begin with? What I do have right here is the agreed final order between Mr. Jaros and Miss Jaros. And again, my congratulations to them. They chose to go 50-50 equal shared parenting with no child support because they both felt that was what caused their children to thrive. Having their children having access to both parents and not one parent being able to use the Office of the Attorney General to extort child support, to have a power control situation over the other parent. That was what actually caused their children to thrive. So once again, congratulations to them. Now, they would say that this is in the best interest of the child, and I'm going to be honest with you. I do not think it's in the best interest of the child. This is my opinion. I am hopeful, perhaps that maybe in the future, that Josh and Jessica would actually restore their marriage. This is something that both of their children want. They want to see not just mom and dad equally, but they do want to see mom and dad equally and together, being reared in an intact home, knowing the love and the safety and the protection of both mother and father together. When I first spoke about the issue of equal shared parenting, it was largely because I thought equal shared parenting would actually help to disincentivize the divorce industry, that it would help to keep marriages together, that it would help to reduce the epidemic of divorce that our state and our country is facing, that it would help to reduce the idea that children be raised with only one parent in their lives, a single parent perhaps, or perhaps one parent keeping a child away from another parent. It is in the best interest of the child that a child be reared in an intact home with his or her natural mother and father, period. Hopefully surrounded by a strong extended family, and also by a society that values marriage, and by a state that actually protects marriage. Anyway, once again, my congratulations to both Josh and Jessica. Well done. Well done. Well done. Now, I want to also talk a little bit about this order that I received as well. It is ordered that both of the parents are no longer going to be called conservators, but parents. Can you believe that? The audacity of the state to change the title of parents to conservators has now been revoked. Well, why does the state even have that title to begin with? What they're trying to say, in my opinion, is that the state owns the children. And if you go through a divorce, the state wants to say, we are going to be super parent. But the state actually has failed on its obligations, in most instances, to protect the institution of marriage. Many divorces are avoidable, and the state should actually start defending the institution of marriage, but it does not do so. Many marriages can be reconciled. They don't have to go through divorce, and the state has an obligation to actually seek the reconciliation of both parents, to seek for the interest of the children to be reared in an intact home, not to have the divorce industry run rampant. In our state, we have unilateral no-fault divorce. One person files for divorce, the state always, without exception, 100% of the time, sides of the person who wants a divorce. They always say that the marriage is irreconcilable, that somehow it's irretrievable, that somehow the ability to achieve the legitimate ends of the marital relationships have been destroyed. And yet none of those things are defined. Nobody knows what irreconcilable, irretrievable, or even what the legitimate ends of the marriage relationship means. The state just buys into this lie, and the state becomes an accomplice to the lie. So the state needs to actually step up and quit worrying about how many divorces we can grant and how many child support orders we can give and how many parents we can now call conservators, and actually be stepping forward and trying to preserve marriages for the sake of the children. What I noticed in this final order in the suit affecting the parent-child relationship is that both parents now have equal rights and equal access. Now, isn't this amazing? That's the way that it should be. Two parents created the child. Two parents are responsible for nurturing the child. Both parents have to have equal rights and ability to direct the child in their upbringing. There may be some instances when those rights need to be curtailed, but the absurdity of the Texas practice is this. If somebody files for no-fault divorce, the state turns around and tries to find who's at fault parenting, who's the worst parent, who's the better parent. If you have no-fault divorce in Texas, and if you've said there's no fault, it's no-fault divorce, it just become insupportable, then both parents should have 50-50 shared equal custody. If you want to go to a fault-based marriage, you can make it the argument that perhaps 50-50 is not that which should be granted automatically, and I would make that argument. But when you have no-fault divorce being the reason for the divorce, there is no reason from my perspective that 50-50 equal shared parenting, where both parents equal rights and equal access to the children, are upheld by the state of Texas. I also looked through this order and I saw that neither parent has exclusive rights to name the residence of the child. And the interesting thing about the exclusive right is when you give a parent an exclusive right, you have automatically diminished the other parent. You are changing the power dynamic. You are saying the state will back one parent against the other parent. The one parent to whom the exclusive rights have been given is now the dominant parent. And for all intents and purposes, that parent can leverage the power that he or she has and exclude the other parent from the life of the children. There are no more exclusive rights to who is going to name the residence of the children. It is also ordered that, and it talks about Mr. Jaros and then Miss Jaros, that the following additional rights with respect to the children are being given. To me, the question comes down to this: who is the state to give parents additional rights to their children? The state is making the argument, therefore, I believe, that somehow they now have the rights to determine who is going to be the parent and who is not. Who is going to get the additional rights? Who is going to get the exclusive rights? This is something that needs to be done away with. Two people in private created a child. They were responsible for nurturing the child. The state needs to make its case as to why it should be dictating the rights of either parent with regard to the child, in my opinion. It also says that both parents are ordered to provide a safe, stable, and nonviolent environment for children and make reasonable attempts to assure that the children will have frequent and continuing contact, communications, and visitation between and among each parent and child to optimize the development of a close and continuing parent-child relationship while minimizing disruption of each child's education, daily routines, and associations with friends. So this title was called Minimizing Disruptions. To me, that seems to be a little bit discriminatory on its face. Why are they singling out divorced parents or parents that have never been married? Why don't they also include married parents in this? If the state of Texas wants to practice non-discrimination, then it should apply to everybody. Married parents should be given the same order. But they don't do that, because if a child is reared in an intact family with two loving parents, the state says there's no reason for them to be involved. In a situation of divorce, in many instances, there is still no reason for the state to be involved. If the state wanted to start defending and protecting the institution of marriage, perhaps it could make the case. But with no-fault divorce, The state is actually changing, once again, the whole family dynamics. Minimizing disruptions, that should be a natural for everybody, whether together parents or not together parents. And children should have the right to associate and to be with both parents. Children usually love both parents and want to be with both parents. The best interest of the child is for the parents to be together. In this instance, they're not. And again, I hope that Mr. and Mrs. Jaros do get back together. That would be my wish for them. I'm not saying that anything will happen, but that would be the best interest of their children. But until then, the state says minimize destructions. So I think that the state should also should make that same order to married families as well. The court finds that the following orders are in the best interest of the children in the suit. And now here they're talking about possession and access. The state is talking about the best interest of the children of this suit. Would the state please define for me what the term best interest means? There is no definition. And what it comes down to is the state finds that the following orders are in the best opinion. The opinion of somebody who is a stranger to the children. The best interest of the child is undefined. Oh, but there are factors that help us to determine the best interest of the child. Strangers are determining the best interest of your children. This should be something that parents should do, but parents should have the ability to choose the best interest of the children, whatever that term means at all. The state, if the state wants to talk about the best interest of the child, the state needs to come out and define what it means. The Texas Family Code has never defined the best interest of the child. The best interest of the child is the magic phrase that they use for anything. For anything. The best interest of the child can mean 50-50 shared custody. The best interest of the child can mean one person has to pay $3,000 a month in child support. The best interest of the child can mean that one parent gets to be the gatekeeper over the children's relationship with the other parent. The best interest of the child is for the child to be raised in an intact family with his or her natural mother and father. And now they also give orders as to the possession of children on the week-on, week-off possession schedule. First off, Mr. and Miss Jaros came to this agreement on their own. Why is the court and why is the state and why is the office of the Attorney General even necessary for this situation at all? I don't quite understand that. When they give an order, it means they are assuming jurisdiction. And we've got to start pushing back against this unjust jurisdiction, in my opinion, that the state is trying to exert upon a family. The state is basically telling you, we own your children. Mr. and Mrs. Jaros said, we no longer want you in our lives. We want you out of our lives. Because when you have been in our lives, you have helped to destroy our children. You have created disruptions for our children. So going back to this minimizing disruptions, let's make this an order upon the state as well. The Office of the Attorney General needs to minimize disruptions that takes place in the natural parent-child relationship. They do not get to choose a winner and a loser. They do not get to choose a superior parent and decide one as an inferior parent. If they have no-fault divorce, the only logical assumption would be 50-50 equal shared parenting, period. Now, if they want to get rid of no-fault divorce, which they should, they can make a different argument. But right now, our legislature lacks the backbone to do so, and therefore they should not be allowing and permitting no-fault divorce and then trying to find fault with a parent. Now here comes down to the duration of the medical support obligation. And this is where Roland Brown from the Office of the Attorney General really started to wax a little bit more eloquently here, because Roland Brown was there to defend, to make sure that the order actually upheld the medical support and the dental insurance that was necessary for the children. Both parents are working. Both parents are providing insurance for their children. But the state of Texas, because now the parents are divorced, the state of Texas has to come in there and grant an order, make an order, tell the parents, this is how you now have to run your lives. The state of Texas is being a nub-nose in their lives. The state of Texas wants to determine what they are going to do in the future. Does the state of Texas do this for married parents that can't afford insurance? Do they? I don't know. Maybe they do. If they do, that would be fine, but if not, they are practicing discrimination based on marital status, in my opinion. and they are finding ways to create a controversy. So if you have no controversy, why do you need to go to court at all? There should be no reason. But the Office of the Attorney General, through these orders, creates controversy that also keeps the court industry well-funded, well-oiled, keeps lawyers very well paid, and actually disrupts people that are trying to be parents to their children, and it plunders their finances. If the state of Texas wants to keep calling people into court, creating this controversy, the state of Texas, that is you taxpayers, should be paying the attorney fees. There is no reason when there's no controversy, or there is a drummed up controversy, drummed up by the Office of the Attorney General, that a person should have to pay outlandish fees just to be a parent to his or her children. Anyway, the court did find that there was good cause for the court to waive the requirement under section 154-181D2 of the Texas Family Code for evidence that either party has applied for or secured health insurance for the children. Accordingly, it is ordered the requirement that either party produce evidence of the court's satisfaction to prove that health insurance has been applied for or secured, or either party has otherwise taken necessary advantage to provide for health care coverage for the children is waived. Once again, is this only for divorced parents that this applies to? If it does not apply to married parents as well, I believe that this is discrimination against divorced parents. And they talk about secondary insurance, they talk about constructive insurance payments received, medical notification, HIPAA notification, but the part that I really want to talk about right now is the child support judgment. Because when it comes right down to it, all of these flowery words about, well, we're here to look out for the children, we're here to make sure that this is in place, we're here to make sure that that is in place. The reality is, in the majority of instances, if not all instances, the biggest concern of the Office of the Attorney General is, will we get our money? And here's what it comes down to. It is found and confirmed that Mr. Jaros, an obligor, is in arrears in the amount of approximately $36,000 as of September the 16th, 2021. This includes all unpaid child support and any balance owed on previously confirmed child support arrearages or retroactive support judgment as of specified date. Now remember, this was a child support order that was imposed upon Mr. Jaros by the court. Both mother and father could have adequately provided from the beginning, but because there was a divorce, the state of Texas and the Texas Family Code says, well, we must have a child support order to accompany this so that we can collect money. And the reason for this, as most people know, is when the state of Texas collects money, they also receive funds from the federal government under Title 4D. In fact, in the Texas Family Code, section 201.107C, it specifically states that a judge shall, that's the mandatory shall, and is authorized to take action so as to maximize Title 4D payments. Title 4D federal funds. So child support is a very important part of the Office of the Attorney General's obligation, their mission. If you look at it and they talk about their mission, the collection of child support ranks right up at the top. I believe it's the second most important function that they talk about when they talk about the mission of the Office of the Attorney General. The reality is the majority of their employees work for the Child Support Enforcement Division. I'm not sure what the exact numbers are right now, but at one point in time there were 4,200 employees for the Texas Office of the Attorney General. Over 2,600 of them worked for the Department of Child Support Enforcement. And I also saw here too that it talks about the release. So the Office of the Attorney General, it is found and confirmed that the Attorney General relinquishes any further claim to the $36,714.46, representing the obligee's share of the judgment, including any and all interest which may have accrued. Interest? Any and all interest that may have accrued, which is not assigned to the Attorney General as the 4D agency. It's right here, the 4D agency. So you see, this is a scam. The judge actually must make a child support order in such a way so that the state can collect Title 4D funds, and it talks about the Title 4D agency, which is the Office of the Attorney General. Now this is, the Attorney General has not chosen this for himself. This is under, the legislature has made that, he is the Title 4D agency. So sometimes when you're upset with the Office of the Attorney General, it's really the legislature that you should be complaining to, that you should be on. the Office of the Attorney General has to do his job, and this is one of these functions that he has to do that maybe he finds distasteful, but he still has to do as part of his obligation. But it is further found and confirmed that Ms. Jaros, an obligee, releases the said $36,714.46 of child support judgment, representing the obligee's share of the judgment, including any and all interest which may have accrued, which is not assigned to the Attorney General as the 4D agency. So once again, there is some money going to the Title 4D agency, the Office of the Attorney General, the state of Texas, in child support orders. So by the way, one of the things that I found very interesting right here, with interest as provided by the laws of the state of Texas at the rate of 6% per annum for collection and distribution according to law. If you get behind on child support, it's like a credit card. No, they're not charging you 25 or 29% or 16%. 6% is what the Office of the Attorney General, what the state of Texas charges you if you are behind. If you have to go to prison because you have been found to be in arrears on child support and they say you are in contempt of court, not only does your child support obligation continue to increase, your interest on the arrears continues to increase. A child support judgment is granted after release against Mr. Jaros and in favor of the Office of the Attorney General in the amount of $0. Because the Attorney General actually decided to release this obligation to them on behalf of Ms. Jaros. Ms. Jaros released the obligation, the Office of the Attorney General released the obligation. However, this was one of the issues of protest that Roland Brown from the Office of the Attorney General was contesting in the hearing. Anyway, this goes on and on and on, and I'd like to also make a comment about this too, because about a year and a half ago, Mr. Jaros, maybe it was 2 years ago, Mr. Jaros was thrown in jail for 6 months because he was found in contempt of court because he was unable to pay the child support, either unable or unwilling to pay the child support, the extortion fee that the Office of the Attorney General was imposing on him. I know there was a lot of controversy around that. I actually supported Mr. Jaros because somebody had to take the stand, and I'm glad that he did. I'm glad that he did, and now has been able to challenge this. And I think that this actually provides a template for everybody in his case, that we can have agreements and keep the Office of the Attorney General out of the agreement. Tell the Office of the Attorney General, you're gone. We don't want you. You cause disruptions, and you actually are creating disruptions that work against our children. But the question that I had with Mr. Jaros and his jail term was this. Article 1, Section 18 of our Texas State Constitution says no person shall ever be imprisoned for debt. The state of Texas put him in prison for the debt that he owed to the state. And the way they got around doing that is they said he was in contempt of court. This is hogwash. It's verbal nonsense. It is a way for the state, once again, to plunder parents and to cause disruption between the relationships. They also talk required notices to the party and different things like that. There's a page of that takes place here. Attorney fees, they talk about, both went pro se. Mr. and Ms. Jaros went pro se. They had an agreement. There was no reason for them to actually have any attorneys whatsoever, except that the Office of the Attorney General, Mr. Roland Brown, wanted to mediate this whole thing because he was not in agreement. He was going to cost them money. And if the Office of the Attorney General wants to mediate something, it is my opinion that the Office of the Attorney General should pay the fees of both sides of the people that are involved in this situation. Anyway, both Mr. and Mrs. Jaros signed this. It was approved. Again, my congratulations to Mr. and Mrs. Jaros that you came together on this, that you chose to look out for your children, that you actually said the best thing for our children, the way they will thrive the most, is for them to have 50-50 equal shared parenting with both parents with no child support. Mr. and Mrs. Jaros, thank you for doing this. And once again, as you know, it is my hope that perhaps even still in the future, there may be some additional opportunity for reconciliation so that you also engage in holy matrimony once again, because your children not only need both of you as parents, it's preferable for them to see both of you together in the same house, that they can see a mother and a father who went through very difficult times, but they came back together They learn to be committed to each other. They learn to love and forgive each other. And that's what I'm hoping for. That's my desire and hope for you. But once again, until that time comes, if it comes at all, just want to say thank you for doing this, for standing up for your rights, for providing a way for many people to follow. Got nothing but good things to say about this. Thank you to both of you. And that's it. Thanks so much.